Yes, which one are you placing?
Well, I'll place from item number 16, which is the lead matter,
What is the
M80
number?
509.
It is 509 number M80
50.
State is the appellant.
In both the matters, state is the appellant. We have come up against a common order, which is at page 54 of the paper book.
Maybe file our exceptions.
Let the exceptions, as filed, be kept on record. Exception to what?
Exception to the report filed by the state. That was there, Lordship's order, last order. Lordship may kindly have a look.
Initially, when the matter was taken up by the erstwhile bench, the appellant was directed to disclose the year-wise vacancies. We have disclosed the year-wise vacancies by a way of an affidavit to which they wanted to file an exception.
Put at the line.
An original record
exceptions to
that has not been done, man.
Original record, the earlier order passed by Justice Homen Sen and Justice Uday Kumar. There was a direction to pay year-wise vacancy, disclosure of year-wise vacancy along with the records, all documents.
You understand that?
Lots.
Let the exceptions to the report as filed be kept on record. Yes.
The crux of the matter, lies in the fact that initially, there was a these are for the recruitment in the post of supervisors of ICDs. Now, initially the ratio was 75:25 for promotees and direct recruitees.
75
5:25.
This is for promotees and direct recruits.
75 for direct and 25 for promotee.
Yes.
Now,
this was notified by.
But this was the prevailing ratio prior to 15th of September 2015.
15 September 2015.
On 15 September 2015, the Government of India issues a memo, thereby suggesting that the ratio should be 50% for direct and 50% for promotees.
No, then prior to 15th of September 2015.
75% direct and 25% promotee.
Now, subsequently, it became
50-50. It was suggested so. It was suggested.
Central government suggested.
Yes.
And state government implemented.
State government implemented.
Yes.
From 15th of September 2015.
From 15th September 2015. 50-50.
50-50.
Yes.
Now the state adopted a formula by which the vacancies which arose prior to 15 September 2015, those were applied with the ratio of 75:25. And the vacancies which arose after 15th of September 2015, the ratio which was applied was 50-50.
And when was the recruitment conducted?
Recruitment was conducted, by a notification of 25th of February 2019.
Notification 25th of
February 2019.
Give us the page.
Page 51.
25th February 2019. Very good. On the basis of the ratio, what you said.
But we bifurcated the vacancies.
This notification was taking into consideration both vacancies prior to 2015 September and after.
And after. Because there was, in the interregnum, no recruitment took place in this particular post of supervisors.
Now, in this case, how many posts are there?
There are 3, 4, 5, 8 total posts. 3, 4, 5,
and direct recruit.
Total is 3, 4, 5, 8. Now the Honorable Single Judge says
total is 3,
4, 5, 8.
3, 4, 5, 8. Then you conducted the recruitment.
We conducted the recruitment.
Prepared the panels.
And by virtue of an interim order, we have given an appointment of almost up to 50% of these vacancies. 50% of these vacancies. Because
in terms of court's order.
This is in
Interim
terms
order
of the single judge's order.
Single judge's
Honorable
interim
single,
order.
yes, no. The interim order by the appeal court.
Interim order
By the appeal court, permitting us to fill up to 50% threshold.
I see. Where is that order?
Malad, the order date, Malad, is, kindly gives me a moment, Malad.
Have you annexed that
Yes,
here?
Malad.
Page 221.
Malad, kindly take page 219. 219 of the paper book. That is part of the order dated 11th of July 2024. Kindly take the third paragraph at 219.
Yes.
In such circumstances, in order to protect the interest of the rival parties, it would be appropriate to permit the state to grant appointment to the extent of 1729 by way of promotion or by way of direct recruits in each of the category if it so desires. From out of the declared vacancies. While granting promotion or appointment, state will inform the recipient of the pendency of the matters in court, including this appeal. Such appointments, either way of promotion or recruitment, shall abide by the result of this appeal.
Very good. Now you have given appointment in terms of this order in how many posts?
Malad, a bit short of 1729. Malad, exact figure, Malad, I am not having.
Approximately 1729. So this 1729 in two parts, promotee and direct.
Yes.
That is approximately 800 posts each.
No, Malad, about 1700 each. That will be about 1700 each.
Oh no, 1700 each takes you to 3458.
Because Malad, the total vacancies is 3458. 3458.
You are permitted to fill up
1729
1729 posts, out of which, what was the ratio?
By
Out of which
1729 by way of promotion or by way of direct recruits in each of the category. In each of the category.
So that decides the issue finally. You are filling up the post.
That is without prejudice to anyone's rights and contentions. That is only for the purpose.
Prior to determination as to what would be the ratio,
the
court has directed to fill up 170
I'll tell you, Lachima.
for each of the
either way, whichever way the matter is decided, the direct recruitees will not go. Direct recruitees
will not lose their job.
If Malad, the Honorable Single Judge's order is upheld, the direct recruitees will be up to 1729. 1729, not more than that. Therefore, the appeal court has allowed us to take the direct recruitees up to 1729.
No, if 75%, 75-25 is taken,
then the amount of direct recruitees will increase. But it will never go down under 1729.
Then
now the Honorable Single Judge has directed that after the change of the ratio, you apply this ratio of 50-50 to the entire vacancy, irrespective of the date on which the vacancy has arisen. This is, Malad, our point of challenge, where we say that the ratio is to be applied as on the date of the origination of the vacancy. The vacancies which arose prior to 15 September 2015, in those, the ratio to be applied is 75:25, and the vacancies which arose after 15 September, the ratio of 50-50 is to be applied.
So was your recruitment notification to fill up on the basis of 50 to 50 in respect of vacancies which arose after 15/9/2015?
My vacancy notification, the division is not in a straitjacket formula of 1729 and 1729 because we applied a formula.
No, by your notification you altered 75/25 to 50/50 in respect of vacancies which arose subsequent to September 2015.
My lord.
And the single judge directs that irrespective of the occurrence of the vacancies, you fill up 50 to 50.
Yes.
This is the order.
1729 for direct, 1729 for promotees.
So was there any indication to that in your notification that it will be in the ratio of 50 to 50?
So, my lord, if you kindly comes to the notification once, page 51.
You proceed in your own manner. Just these questions are coming.
No, my lord, I'll just indicate one thing, my lord. If you kindly comes page 51 once, then I take your lordship, my lord, directly to the impugned order.
Page 51. What is page 51?
51 is the notification of 25th February 2019.
Rules. Mention into the rules. Kobita.
Yes.
No, what
What you want to show?
509.
Direct recruitment 50%.
Direct recruitment, 50% of the posts of supervisor will be filled up by direct recruitment through a competitive examination conducted by the Public Service Commission, and out of the remaining 50% of the posts, 45 of the posts of the supervisor will be filled up from the Anganwadi workers of integrated child development service, and rest 5% of the posts of supervisors will be filled up of the case workers or so and so.
This is the promotional code.
This is, my lord, where we give effect, my lord, to the 15 September 2015. এক সেকেন্ড প্লিজ, সবাই মিলে তা করলে খুব অসুবিধা হবে না। আপনি আমার ক্লায়েন্টরাও বলছে, তুমিও বলছো, একটু আমি আমার মতো করে বলে নিই, তারপর তোমাকে বলে ঠিক করে নিও ওগুলো। And pursuant to this, my lord,
No, you are by this notification you are giving effect to
15 September 2015, which page I have not indicated as yet, my lord. That is the page 36. I'll place it, my lord, in due course. But the page, my lord, for your lordship's, my lord, kind consideration is page 36. 15 September 2015.
Yes.
And pursuant to, my lord, this notification of 25th February 2019, the advertisement has been issued, that is at page 26.
Is there any mention in the
Now, my lord will kindly take the impugned order. That is at page 54.
Yeah, just one. So this notification was challenged before the writ court.
No, my lord, what they challenged is the notification of 7th of March 2019.
7th of March.
March 2019. That is page 31. Page 31 is the impugned memo.
Just. 7th of March 2019.
This was challenged. Neither 25th February 2019 was challenged, nor, my lord, this advertisement was challenged. Finally,
What is the 7th March? What does it say?
My lord, it is, my lord, a memo by which the director and the controller was directed to make arrangements for enlisting of the eligible Anganwadi workers and case workers, as the case may be, who are willing to take the examination for promotion, for sponsoring the candidate to the Public Service Commission, which will be conduct the selection examination. The guidelines, etc., was laid down by this memo.
Hmm. So the modality of examination was same, that both had to appear in any recruitment test.
No, Malad, one is by
Promotion. But it says examination for promotion. Page 31, second paragraph. Request you to make necessary arrangement for enlisting of eligible Anganwadi workers, case workers as per willing to take the examination
for promotion. Promotion to examination. Same examination. It's a separate examination for the promotees.
Did you refer to that in your earlier memo of 25th February? Eligibility, you have given educational qualification, age for promotion.
Yes, Malad, kindly takes
Para 9B.
52 bottom. 52 bottom is direct and 53 is for promotion. A recruitment 53B, a recruitment test will be conducted by the Public Service Commission in two parts. Candidates sponsored by department and select number of candidates so and so.
Then what happened?
Now, Malad, at this juncture, Malad, kindly takes Malad the impugn.
They challenged that memo.
They challenged 7th March 2019.
Direct recruitees.
Yes.
Who challenged? Direct recruitees.
Direct recruitees challenge Malad. Malad, kindly give me a moment, Malad. The promotees, Malad.
Promotees challenge this. Yes, place 19th of memo, 19th of September 23 order.
Yes, Malad, kindly takes from page
57.
Malad, kindly takes from the relevant part, page 59. Malad, in the before the Honorable Single Judge, we were directed to file an additional report. I am reading from that part, page 59. Bottom. It has been admitted. May I place it, Malad? It has been admitted in the said report that the recruitment to the post of supervisors by way of promotion before September 2015 was required to be done in terms of the guidelines that existed prior to September 15, 2015. The posts which were filled up after September 2015 had to be done in accordance with the procedure laid down in the memo dated September 15, 2015 with effect from the said date.
September 15, that is page 36.
That is page 36.
What is that 36?
Well, that is the central government memo.
Yes.
Therefore, it remained unexplained why, despite of the vacancies that remained to be filled up after September 2015, the state chose to fill it up in 75:25 ratio. By way of a notification dated February 25, 2019, issued by the Joint Secretary, the vacancies which arose prior to September 2015 were ought to be filled up in 75:25 ratio. The vacancies which arose after September 30, 2015 were sought to be filled up by 50-50 ratio. It has not been explained by the state respondent why the memo dated September 15, 2015 has been sought to be interpreted in the aforesaid manner by the state government memo dated February 25, 2019. Furthermore, this court finds that no chart has been annexed with regard to the dates on which the vacancies arose for the posts of supervisors per year. Despite the report on affidavit being filed, it has not been stated why the vacancies which remained on September 30, 2015 were sought to be filled up by the state government in 75:25 ratio even in 2019. Despite the memo dated September 15, 2015 of the central government, how the cutoff of September 30, 2015 has been arrived at is also unexplained. After considering the rival submissions of the parties and the material placed on record, this court is of the view that the directions given in the memo dated September 15, 2015 in supersession of all previous guidelines could not be sought to be interpreted in a manner which would have the effect of curtailing the promotional vacancies of the AWWs to the post of supervisor ICDS. Why the artificial distinction is made between the vacancies which arose prior to September 30, 2015 and after September 30, 2015 is unexplained by the state authorities. Therefore, this court finds that if the vacancies remain to be filled up after September 15, 2015, the same had to be filled up in 50-50 proportion. 50% of the required to be filled by the AWs by way of promotion and 50% was required to be filled up by way of direct recruitment.
But this is contrary to what is said in the earlier paragraph.
Mulad,
paragraph says that why the artificial distinction is made before and after 30th September.
Mulad, the Honorable Single Judge.
Let us understand
Yes.
what.
Only
Is that the why the artificial distinction is made between vacancies prior to September and after September?
Mulad, this.
So was it the mind of the learned single judge that all the vacancies irrespective of the date has to be by 75-25?
By 50-50. Irrespective of date, it is to be 50-50. What is being referred by the Honorable Single Judge, if we go into the meaning of every word, Mulad, what is being called to be an artificial distinction is basically a legal distinction. It is not an artificial factual distinction.
50-50
September.
After September. What is also doing 50-50 good?
50-50 হয়ে যাবে কারণ supersession করেছে on the date of the issuance of the it is an offer. On the date of issuance the contract.
That is separate as the observation artificially 30th September 50 এর আগে
Therefore, this court finds that if the vacancies remain to be filled after September 15, 2015, the same had to be filled in a 50-50 proportion. This is where the Honorable Single Judge is leading to, Mulad. 50% was required to be filled from AWWs by way of promotion and 50% was required to be filled by way of direct recruitment. Only if there were no candidate available who had the necessary experience of 10 years and educational qualifications of a direct recruit to the post of supervisors female only, ICDS, the said vacancy could be filled up by direct recruitment and not otherwise. Therefore, it directs that out of the total vacancies of 3458 to the post of supervisors, 50% are required to be filled by direct recruitment and 50% are required to be filled from the post of AWWs by way of promotion. The objective of such promotional avenue is also not lost upon the mind of this court. The notification dated September 15, 2015 was issued keeping in mind the aspirations of the field functionaries and to encourage their participation in higher posts, keeping in mind their merit in order to improve their career prospects. Such right to be considered for promotion could not be arbitrarily and without any reason be curtailed by the state authorities by holding that the vacancies which arose prior to September 30, 2015 have to be filled up in 75:25 ratio. Accordingly, this court directs the AWWs to be considered for promotion in respect of 50% of the vacant posts of supervisors, the total number of which is 3458, according to the written instructions which were handed over in court by the state respondents. With the direction so and so and so and so, it is disposed of. Therefore, the Honorable Single Judge says that since you have not filled up these vacancies prior to issuance of the central government memo and you have kept these vacancies linger, now this accumulated vacancy will have to apply a 50-50 ratio irrespective of the date on which that vacancy arose. And our point here is that, Mulad, the vacancy as on the date of the origination the law prevailing as on that date of origination of the vacancy, the ratio applicable as on that day of origination of the vacancy, that ratio is to be applied. And accordingly, all the vacancies which arose prior to 15 September 2015, we have applied the ratio of 75:25. And those which arose after 15 September, we have applied the ratio of 50:50. Now, this is the broader issue of law, that which ratio is to be applied and how this memo is to apply. Now, within this, there are certain finer calculations, because some promotions were given earlier, some direct recruitment took place here and there. Due to left-wing extremist areas, some promotions were required. Those had to be calculated. Those has to be taken out from the entire pool. Those I'll place the final calculations later. That is that. But the broader point required to be decided in the appeal is that whether the vacancy, the ratio applicable as on the date of origination of the vacancy, whether that will apply or not. Now, will kindly take page 36.
Yes.
And it takes paragraph 2 first.
3, come 3. Okay, 2.
To give the, to bridge paragraph 3, that in the broad framework of implementation of restructured ICDS approved by the cabinet, with the restructuring and strengthening of ICDS, the following provision for rationalization of appointment of AWWs as supervisors have been made. 25% posts of supervisors reserved for AWWs would be filled up by method of induction under the ICDS mission, subject to fulfillment of desired educational qualification and age criteria, and additional provision for filling up of 20% of vacant posts from AWWs based on their merit and track record for service and additional qualification would be made. The above position has been reviewed, keeping in view the aspirations of these field functionaries to encourage their participation in higher posts vis-a-vis their merit and to improve their career prospects. The following guidelines on promotion and appointment of AWWs to the post of supervisors in supersession of earlier guidelines are conveyed to the states or union territories for compliance. The 50% of vacancies in the post of supervisors would be filled up by promotion from amongst AWWs with 10 years of experience as AWWs and having the prescribed educational qualification as per the recruitment rules for the post of supervisor, which failing which the vacancies would be filled up by direct recruitment. And the remaining 50% vacancies to the post of supervisors will be filled up by direct recruitment. Then kindly text 5. The above guidelines are subject to ratification by the National Mission Steering Group. Therefore, these are not final. This is subject to ratification. Then 6. It is requested that the state or union territories may amend the recruitment rules for the post of supervisors as per the above guidelines on urgent basis, and a copy of such recruitment rules are being notified may be sent to this ministry. Now, this where the states were directed to frame their recruitment rules according to this policy. Now, we actually, the ratio should have been applied from 25th of February 2019 when our rules were amended. But since we have taken the date, cutoff date to be 15th of September 2015, that point is no longer available to me, that I understand. We could have taken the ratio of 50-50 from 25th September because these are not the final things. This is
no
subject
rules were brought into force. No
on
rules.
25th of February 2019, which is at page 51. By this 15th September 2015 is implemented, which I was placing, and by direct recruitment, we say 50% of the post of supervisors will be filled up by direct recruitment through a competitive exam conducted by the Public Service Commission. And B is out of the remaining 50% of the post of supervisors, 45% of the post of supervisors will be filled up by Anganwadi workers of ICDS, and rest 5% of the post of supervisors will be filled up from case workers under the controller of vagrancy, West Bengal, through separate selection test conducted by the Public Service Commission, West Bengal.
So you implemented the 2015 guideline in 2019.
by framing the rules of 2019. Now, my lord, at the cost of repetition,
So you did not, this was the 25th February 2019 recruitment rule framed in consonance with 15 September
2019. Now, my lord,
where is that, this rider which you are adding, the date on when the vacancy occurred? As regards that rider, anything has been stated?
my lord, kindly takes page 51 under B. Under B, just above 4, that in case of vacancies occurred up to 30th September 2015,
Where you are reading?
my lord, just above 4, eligibility.
Note. Achha.
In case of vacancies occurred up to 30th September 2015, the ratio of direct recruitment as indicated in Rule 3A and recruitment from the category of Anganwadi workers and case workers as indicated in 3B taken together will be 75:25 ratio respectively, and in case of vacancies created thereafter, ratio of direct as stated in 3A and so will be 50:50 ratio respectively. Now, my lord, at the cost of repetition, my lord, this rules is not under challenge before lordship.
Notification.
This notification is not under challenge before lordship. The advertisement issued pursuant to this notification is not under challenge before lordship. But, my lord, the memo issued pursuant to this first paragraph of 3B, your lordship has seen this breakup of 45% and 5%. When we wrote to the controller of vagrancy that you please send me the list at this juncture, my lord, this 7th of March 2019, that is page 31, this is impugned in the writ petition.
Where is that letter forwarding?
31. Page 31
is the. Achha. Yes.
But kindly sees, we have written the Joint Secretary of the Women and Child Development writing to Director ICDS and Controller of Vagrancy for this list of names which is required under 3B.
Then what happened?
Now, my lord, then the impugned order, my lord, that I have placed, my lord. Now, my lord, before the Honorable Single Judge, my lord,
read the first paragraph of that. I am
directed to inform you that the 55th meeting of the Cabinet held on so has approved vide so recruitment rules for the post of supervisors under ICDS, that is page 51, and filling up of the vacancies of 3376 posts of the supervisors on the newly framed recruitment rules, copy attached, of which 422 number of posts will be filled up by promotion by selection from Anganwadi workers under ICDS, case workers and under the control of vagrancy. Remaining 2954 posts will be filled up by direct recruitment through a selection process conducted by the Public Service Commission.
As per note of 3B.
As per note of 3B.
Yes.
Now, my lord, before the Honorable Single Judge,
this was challenged.
This was challenged.
Yes.
Now, my lord, the promotees are aggrieved by the fact that 2954 posts are being filled up by the direct recruitees and only 422 number of posts are left for the promotees. This is the crux of the issue. Now, my lord, before the Honorable Single Judge, we had filed an additional report which has been referred to by the Honorable Single Judge. Now, my lord, if your logic kindly comes to that, which is starting at page 38 and kindly comes to a relevant page at page 40.
এটা যদি জানেন
nothing but the consequence of the subject the scrutiny of this bill.
নোট নিশ্চয়ই জানেন, নিশ্চয়ই আর্গুমেন্ট
সেটার আমাদের এটা ফিগার 2376
So when did the process start? After 19, when were the tests and everything were held?
Advertisement date কত?
Do you have you indicated that?
The advertisement
Where is the
page
advertisement?
26, but it is not having the date.
Page 26.
6. I'll just try to find it out from their pleadings. Not even in their pleadings, it is not there.
Must be subsequent.
Subsequent to the rules. Subsequent to 7 March.
March.
Subsequent to 7 March.
Uh-huh.
But my verbal instructions is that it's 8th March, but it is not appearing from the documents, my lord. I'll clarify.
Now on the when was the writ petition filed? After participating or before participating?
My lord, this is in 5th of March 2022. After publication of everything.
Oh, after publication of list.
After 3 years. Almost 3 years.
So when was the list published? Procedure was completed. Everything was done. When was the list?
My lord, when we had started giving some recruitments. We were already in the process of giving some recruitments. At this time, the Honorable Single Judge's order comes. Therefore, my lord, it got stalled. Then again, my lord, by virtue of the order, interim order here.
Achha, when was the list published? This
I'm giving that date.
No, this writ petitioner did avert that yes, I participated in the proceeding. Papia, Ghoshal, and others. All right, we shall ascertain that. Now you continue. What happened?
You ask your junior to
I'll check that. I'll check.
petitioner participated in the promotional process or recruitment process also.
There were 2 examinations, na? One for direct, one for promotion.
Promoted date bolun.
Yes, you proceed.
Promoted examination date dekhe niন. Kindly text now the additional report filed by the before the Honorable Single Judge at page 40. I am showing this apropos to the finding of the Honorable Single Judge that it has not been explained by the state why the memo dated so and so has been sought to be interpreted in the aforesaid manner so and so. This court finds that no chart has been annexed with regard to the dates on which the vacancies arose so and so. This exercise is today complete. Kindly take page 40. Now, my lord, kindly takes from in the chart at serial number 1 and serial number 2. Yes. My lord will kindly take serial number 1. Your lordship will find that between serial number 1 and 2, we have bifurcated between September 2015 and pre-September 2015 and post-September 2015. Serial number 1.
What is B? Year and month of the vacancy?
Yes, that is, my lord, what is in serial 1, this entire row is pre-situation as on September 2015. And serial number 2 is from September 2015 to January 2019.
Why January?
Because one of the recruitment rules comes in February 29. So, for explaining before the Honorable Single Judge, we have put January 29. Then, my lord, column number C is the number of supervisors in service as on that date. Then D is out of this total, the direct recruitees which is available to us. Then E is the promotees which is available to us, which is already in service. Therefore, in the ratio of 75:25, the directly selected is 1462 and the promotee should be 487.
Yes.
Therefore, we find that applying the ratio of 75:25, there is an excess of 498 in the promotee category.
Yes.
The number of in service 1949 ছিল আর 75:25
এইটাই
487.
হ্যাঁ এই 497 কি
How you are calculating this 498?
Yes, Malad will kindly take the total number of in services 1949.
Yes.
Malad, out of this, we from our records we can find out who are direct and who are promotees, which we have given in DNE.
Okay.
If we apply the ratio, prevailing ratio of 75:25, a certain figure is supposed to come.
Yes.
Should be.
It should be. It should be so and so and so and so. Therefore, we find that 498 promotees are excess in our cadre. Similarly, in serial number 2, we have given the same ratio because now it will be 50-50. So out of 1500, it should be 750 and 750. And from our cadre, we find that 16 number of promotees are extra. This is what is extra. This is the prevailing position. Now kindly comes to the computation, that is from serial number 4 onward. Serial number 4 is the number of supervisors sanctioned as on September 2015, that is 4958. Out of this, serial number 5 is the number of supervisors in the position, that means in service, as on September 2015, that is 1949. Same figure as in serial number 1. Therefore, my lord, the vacancies is 4958 minus 1949. The vacancy is 3009 as on September 2015. Now the ratio which is to be applied is 75:25 according to us prior to September 2015, which gives a bifurcation of 2257 and 752. That is serial number 6, 5 and
257 is direct and 752 is promoting.
Yes. Now, in our cadre, we have found, as previously mentioned, that 498 is in promotees are in excess.
Total 514. Okay, 498, yes.
Yes, 498 is in excess. That is serial number row 1, column H.
No, but why you are justifying the such action? You have filed the court has 70. Your clear case is 75:25.
Is to 25. But because
you're saying
I need not, because I will place decisions to show that court need not go into this calculation at all. Court need not go into this calculation at all, because it is to be left for the experts to go into this calculation.
Your argument is that there is enough material on record. You are justifying this thing to show that there is no such fluctuation since there were previous vacancies exist.
Yes.
That is what you are hinting.
Yes. That I wanted to show from the chart, Malad. I bow down to what is following from Lordship, Malad. The nitty-gritties of the calculation is not important at all. Need not be gone into, because Malad, the broader point of law which is required to be decided.
You argue on that.
Yes, that what is the ratio which is to be applied prior to this date, or have we gone wrong in applying 50-50 by accumulating these vacancies up to 2019, by not conducting a recruitment process in the middle. That is what the Honorable Single Judge holds, that you have not conducted a recruitment process in the interregnum. So you have accumulated all these vacancies up to 2019. Now on 2019, the applicable ratio, applicable law is 50-50. Now you cannot go back to 75-25.
Yes. So, what is your argument? So from this chart, you are wanting to show the status of the vacancies. Status of the vacancies.
Yes.
And how it was filled.
How this is the calculation, my lord, which has been given, my lord. Lordship may not go into that calculation. My lord need not go into that calculation. But my lord, my endeavor is to show that we have applied 75 to 25 and we had laid it out before the honorable single judge that how we have made the calculation. How we came to this figure. We came to this figure mentioned
No,
in
that
the
is not the challenge in the writ petition. Writ petition challenge is you cannot do this in this ratio.
In fact, that is also not the challenge. In fact,
No,
that
whatever,
is
at base, that is the
that is the perceived challenge. That is the perceived challenge that this our calculation has been challenged. Whereas what is under challenge, my lord, I in the other writ also I have checked up. What is under challenge is my letter to the director of ICDS and controller of vagrancy that give me the names. Now, my lord, as I said, my lord, what is being described as an artificial distinction, my lord, is actually a legal distinction, my lord. To in support thereof, my lord, if I may place 1998, volume 9 SCC 223. এখানে নতুনটা নেই, পুরোনোটা আছে 223 এরকম, এগুলো এরকম কেন? এগুলো বাঁধতে বলবে ক্লার্ককে, জজকে এরকম স্টেপল দেয় না।
সেটাই চ্যালেঞ্জ বললে রেসপন্ডিং ছিল তো
So kindly take paragraph 9. Report 1983 to work with.
Yes.
Kindly take paragraph 9. May I place it, Mullah?
Yes.
When the statutory, page 226, paragraph 9. When the statutory rules had been framed in 1978, the vacancies had to be filled up only according to the said rules. The rules of 1995 have been held to be prospective by the High Court, and in our opinion, this was the correct conclusion. This being so, the question which arises is whether the vacancies which had arisen earlier than 1995 can be filled up as per 1995 rules. Our attention has been drawn by Mr. Mehta to a decision of this court in T.N. Devinkatti versus so-and-so. In that case, after referring to earlier decisions in so-and-so and so-and-so, it was held by this court that the vacancies which had occurred prior to the amendment of the rules which would be governed by the old rules and not by the amended rules. Though the High Court had referred to this judgment, but for the reasons which are not easily decipherable, its applicability was only restricted to 79 and not 171 vacancies which admittedly existed. Now, my kindly take paragraph 11 in the next page. We are informed at the bar by Dr. Singhvi on the basis of the instructions received by him that now there are about 323 posts of assistant accountants. Out of these, about 80 have been filled on the basis of December 1973 examination. The respondents are directed to fill 91 more vacancies on the basis of December 93 examination, which they have already conducted. This will leave a balance of 152 vacancies. The number of persons who are holding these posts on current duty charge appears to be less than the number of vacancies so available. Therefore, there will be no immediate danger of Mr. Sanghi's client being reverted to the post of senior clerk, the respondents will be at liberty to continue to retain them in the higher post. But it is made clear that the vacancies which had arisen prior to the amendment of the rules in 1995 can only be filled in accordance with the 1978 rules, which means that if Mr. Sanghi's clients want to be regularly appointed as assistant accountants, they will have to compete with and take the examination under the 1978 rules. So, if the rules are prospective in nature, the earlier rules will apply for that part of the vacancies. Next, will kindly take 1983, volume 3. বেশি নেই, তুমি সিনিয়র মোস্ট গুলো তোমাকে দিলাম, কাউকে দিতে পারবো না। 1983, volume 3, SCC 284. I will kindly take paragraph 9. I will kindly skip over 6 lines. Kindly skips over 6 lines. So I am having a different copy. Kindly pardons me. Kindly skips over. Para 9. Kindly takes from the 9th line. 9th line starting with the vacancies which. The vacancies which occurred prior to the amended rules would be governed by the old rules and not by the amended rules. It is admitted by the council for both the parties that henceforth promotion to the post of sub-registrar grade 2 will be according to the new rules on the zonal basis and not on the statewide basis, and therefore there was no question of challenging the new rules, but the question is of filling the vacancies that occurred prior to the amended rules. We have not the slightest doubt that the posts which fell vacant prior to the amended rules would be governed by the old rules and not by the new rules. Therefore, what is important is the date of origination of the vacancy and not the date of filling up of the vacancy. Next, your Lordship will kindly take 1990, volume 1, Supreme Court cases 411.
Rangaiah was distinguished in the School Service Commission matters.
I see. Therefore, backup kindly takes 1990, volume 1. Paragraph 5.
Larger bench.
This is
paragraph 5.
yes, paragraph 5.
Paragraph 5. I will kindly take from
On the same proposition.
same proposition. It takes from the 7th line. In the absence. In the absence of any express provision or necessary intendment, the rule cannot be given retrospective effect except in the matter of procedure. The amending rules of 1979 do not contain any express provision giving the amendment retrospective effect, nor is there anything therein showing that the necessary intendment for enforcing the rules with retrospective effect. Since the amending rules were not retrospective, it could not adversely affect the right of those candidates who were qualified for selection and appointment on the date they applied for the post. Moreover, as the process of selection had already commenced when the amending rules came into force, the amended rules could not affect the existing rights of those candidates who were being considered for the selection, as they possessed the requisite qualifications prescribed by the rules before its amendment. Moreover, construction of amending rules should be made in a reasonable manner to avoid unnecessary hardship to those who have no control over the subject matter. Now, my lord, this is one group of judgment, my lord. Another 2 judgments I want to show, my lord, because, and I am needed to show those, my lord, because the finding of the Honorable Single Judge going into that question, that at page 60, I'm only reading it for reference, my lord, that it has not been explained by the state respondents why the memo dated so and so has been sought to be interpreted in the aforesaid manner by the state government. Furthermore, this court finds that no chart has been annexed with regard to the dates on which the vacancy arose for the post of supervisors per year. Despite report of affidavit being filed, it has not been stated why the vacancies which remained on 30th September 2015 were sought to be filled by the state government in 75:25 ratio, even in 2019 and so and so. Now, my lord, my point here is that these calculations or these uh, points of vacancy, etc., were not needed to be gone into by the honorable single judge. What was, if at all, this perceived challenge to the rules? It should have been restricted the query, the inquiry in the judicial review ought to be that what ratio is to be applied. What was the law in this regard? My lord, on that subject, my lord, kindly takes 2011, volume 15 SCC, paragraph 16.
Page
16, my lord. 2011, volume 15 SCC, page 16. Paragraph 28 and 39. Oh, sorry. The last moment. I take paragraph 28, my lord, that recognizing the difference between the public and private law activities of the state, this court reasoned that the unlike private individuals, the state, while exercising its powers and discharging its functions, acts for public good and in public interest. Consequently, every state action has an impact on the public interest, which would in turn bring in minimal requirements of public law obligations in the discharge of such functions. The court declared that to the extent that the challenge to the state action is made on the ground of being arbitrary, unfair, and unreasonable, hence offensive to Article 14 of the Constitution, judicial review is permissible. The fact that the dispute fell within the domain of contractor did not declare this court relieve the state of its obligation to comply with the basic requirements of Article 14. Then can I take paragraph 39? A writ court is entitled to judicially review the action and determine whether there was any illegality, perversity, unreasonableness, unfairness, or irrationality that would vitiate the action, no matter the action is in the realm of contract. Having said that, we must add that judicial review cannot extend to the court acting as an appellate authority sitting in judgment over the decision. The court cannot sit in the armchair of the administrator to decide whether a more reasonable decision or course of action could have been taken in the circumstances. So long as the action taken by the authority is not shown to be vitiated by the infirmities referred to above, and so long as the action is not demonstrably in outrageous defiance of logic, the writ court would do well to respect the decision under challenge. So, these nitty-gritties of calculation, whether few vacancies should have been here, whether few vacancies should have been there, so it was not required to be gone into at all. The other one, the last one, 2023 SCC Online SC, 344. Sorry, 344. Tajveer Singh. Kindly takes paragraphs 65, 66 and 67.
Yes.
65, Mulad, is at internal page 26.
Yes.
Before proceeding further, it is necessary to preface our judgment with the view that the courts in India generally avoid interfering in the selection process of public employment, recognizing the importance of maintaining the autonomy and integrity of the selection process. The courts recognize that the process of selection involves a high degree of expertise and discretion, and that it is not appropriate for the courts to substitute their judgment for that of a selection committee. It would be indeed treading on thin ice for us if we were to venture into reviewing the decision of experts who form a part of the selection board. The law on the scope and extent of judicial review of a selection process and results thereof may be understood on consideration of following case laws. Now, the quotations I am not placing, Malad. Kindly turns over to paragraph 66. 2 pages, Malad. In the third page, page 66. Paragraph 66. Thus, the inexorable conclusion that can be drawn is that it is not within the domain of the courts exercising powers of judicial review to enter into the merits of a selection process, a task which is the prerogative of and is within the expert domain of a selection committee, subject to a caveat that if there are proven allegations of malfeasance or violation of statutory rules, only in such cases the inherent arbitrariness can the courts intervene. Thus, the courts, while exercising the power of judicial review, cannot step into the shoes of the selection committee or assume an appellate role to examine whether the marks awarded by the selection committee in the viva voce or excessive or corresponding to their performance.
But the selection committee marks
not
the higher pedestal.
I have the guidelines being that the job of the experts are to be left with the experts.
Thank you. Yes, who is appearing for the...
Malad, may I indicate the 2 pages of the prayers, Malad, of the writ petition? Malad, in the appeal from which I am placing, Malad, the prayers are at page 22. And in the other appeal, Malad,
yes,
the prayer is at page 90.
Same prayer, same prayer. And
Malad, your lordship has inquired for a date. Malad, the results were published on 3rd of February 2023. For direct recruitees. Promoted to dile na to date ta din.
3rd of February
2023. The impugned order is 19th of September 2023. সেপ্টেম্বর বলেছিলেন ভাই, শুনুন না, আপনি শুধু ওইদিকে শুনছেন, এদিকে শুনছেন না।
বলবেন দেখুন না 75 কমানো তাহলে কমলো 25%, 25%।
Before I conclude, Malad, there are certain applications which has been kept pending, which was the desire of your lordships that to be heard with the final matter. But if those applications are at all placed, kindly allow me to reply to those applications in my reply. When I reply, Malad, to my learned friends and learned senior friends also, Malad, I'll reply to the applications as well, Malad, which has not been allowed as yet.
Come on 13th and finish it off, and Mr. Bandyopadhyay, you also be here to whatever reply you want to give. Please finish it off on
13th. We do not consider usually in our culture as anything bad. 13th is nothing wrong. We have 13th sit also.
Don't forget that.
Well, only one short point. Can 6 and 7 we will address on 13, not more than 10 minutes, man. Can 6 and 7.
Sir, we are keeping it at 2 p.m. Without your assistance, we cannot finish. So we hope that you will assist us and finish your argument so that we can deliver the judgment. Good, bad, indifferent, higher forum is there.